We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. My name is Amy Blake. I'm pleased to be joined today by Justice James Lemire and Justice Rachel Hershfang. We are hearing one case today called DUNN versus GENZYME. I remind counsel that although we're doing this virtually, the rules still apply. That is, each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your papers, so you should feel free to get right into the issues. And with that, 21P455, Mr. Dunn, when you're ready.
May it please the court, Your Honor, Matthew Dunn for Patricia Dunn, who is the moving party here. I don't think I'm going to need the full 15 minutes. I think this is a fairly straightforward issue that's been addressed by this court on numerous occasions. This is an appeal of the Norfolk Superior Trial Court's judge's denial of Mrs. Dunn's motion for relief from judgment, which she brought.
Mr. Dunn, if I could ask, you had to file a 60B because after the SJC decided, I guess it would be DUNN 2 at that point, the case was dismissed. So you couldn't file a motion for relief to file a further amended complaint.
Well, Your Honor, initially it was unclear to me whether or not the case was dismissed or whether it was simply remanded back to the trial court to correct the pleading deficiency with regards to the additional facts that the SJC indicated were needed to assert this parallel state law claim seeking a damage remedy. So initially what I did was I submitted a motion to amend the complaint, and that motion was actually returned to me with a clerk's entry indicating that the case had actually been dismissed, and that's what precipitated the need for filing this motion under.
Was it dismissed with or without prejudice? Because I wonder if you could have filed a motion to vacate the dismissal consistent with the SJC decision and then seek leave to file a further amended complaint.
The SJC's decision, Your Honor, is a bit curious in that it seems like if you read this sort of the last page of it, it seems like it just sort of abruptly stops. And there's no indication of whether or not the case was dismissed with prejudice or whether it wasn't. And so that's what created this ambiguity and sort of this these two motions. Again, first was to amend the complaint. The other one was to seek relief from judgment after it was indicated to me by the clerk that the case had in fact been dismissed. So that's what when I brought the motion under 60B1 and 60B6. And the appeal is really, there's really three parts to the appeal. The first part is the judge, just for oversight, neglected to even address the Rule 60B1 argument that was presented in the motion.
Was it timely?
Yes. So this whole motion practice with regards to seeking to amend the complaint or relief from judgment, this happened within weeks of the SJC's decision on GENZYME. It was actually GENZYME's appeal of a motion to dismiss. So GENZYME brought a motion to dismiss initially in the Norfolk Superior Court. Their motion was denied. GENZYME appealed that to a single justice of this court, who referred it to the full panel, and then the SJC wound up taking the decision sua sponte up to its court, and then the matter with regards to the motion to dismiss was briefed and heard before that court. So there's never been any discovery. There's never been any sort of trial on the merits of or an adjudication on the merits.
Can I back you up though again on the 60B? I understand the 60B6 argument, but on 60B1, are you tagging that to the SJC decision, or should it be more properly tagged to the date of the complaint?
I'm sorry, you're saying?
So you're under 60B1, right? You have 1 year?
Correct.
And when does that 1 year begin to run?
So I would say it begins to run on the date of the dismissal. And the SJC's decision is unclear whether or not the case was dismissed. When I got clarification was when the pleading with regards to moving to amend the complaint was returned to me with a clerk's entry that said that the case had been dismissed, and that's what precipitated the Rule 60B1 and 60B6 motion on my end, because it was my understanding at that point that the case had been dismissed and I had to seek relief from the judge or from the judgment that had entered against Mrs. Dunn at that stage.
Attorney Dunn, can I just jump in a little bit on this, the procedural history? I agree with you, having looked at the last page of the SJC's decision, that it's not entirely clear whether or not the case was dismissed with prejudice. As I look at the trial court docket, and so right now I'm on page something, I think 8 of the record appendix. I do see on February 4th, 2021, judgment was entered on the docket. Again, no clarity as to whether the dismissal was with or without prejudice. But it does say as of February 4th that the case was ordered dismissed, and it cites the Supreme Judicial Court's decision. So, you know, and then the next thing is 12 days later, I see your notice of motion to amend. So I think the question of whether the dismissal was with or without prejudice is one that might be meaningful and doesn't seem to have been addressed on the record. I guess I do want to just make sure I'm understanding one even more basic threshold fact. Do you agree, Attorney Dunn, that it's too late? In other words, the statute has run. If you can't file an amended complaint or a complaint that refers back in some way to the initial filing date, Mrs. Dunn is out of luck. Is that true?
You're saying that the statute of limitations would have run in the event that the case was dismissed without prejudice? And that
That's right.
It needed to be refiled, if that's what you're saying. Then if
it couldn't be refiled. In other words, any new complaint would have to go back to the original filing date. It would have to be an amendment rather than a new complaint in order to satisfy the timing requirements. Is that right?
If and I didn't brief this issue, but if it was the position of the court that the filing of the new action does not relate to the original action, then yeah, it would be beyond the statute of limitations at that point. Okay. But it was unclear to me that whether or not the case was dismissed at all to begin with, and whether or not it was dismissed with prejudice or without prejudice. I just thought based on the SJC's decision, that was unclear to me.
All right, but let me interrupt if I may. Bottom line is judgment has entered as of February. It was dismissed, but judgment entered, a judgment of dismissal entered on the case. So it's a final judgment. You filed a Rule 60B motion, and the judge denied your motion. Do you agree that we review that denial under an abuse of discretion standard?
I do agree with that, but Your Honor, the judge.
You agree that it is not a substituted judgment by this court, but whether or not the judge abused his or her discretion in the lower court.
I agree with that, Your Honor.
All right, so tell us where the judge abused their discretion.
Okay, for primarily the abuse of discretion occurred by the fact that there was the Rule 60B1 argument was never addressed in the judge's decision. If the court would look at the trial judge's decision, only Rule 60B6 is addressed. Rule 60B1 is not. And with regards to abuse of discretion, there's a standard that's been established by this court that talks about that the trial judge is supposed to weigh the factors that are relevant to the decision, in that the decision falls outside the range of reasonable alternatives. By simply not addressing the standards that are set forth in the Berube case, the judge failed to weigh the factors that are relevant to a decision under Rule 60B1. And by definition, that would constitute a clear abuse of discretion that would warrant this court's reversal of that decision.
Did you file a
Secondly,
motion for a clarification or reconsideration? I know it, as a former trial judge, it's not uncommon for judges to miss a particular claim when there are multiple claims, and sometimes someone has to bring it to your attention and say, hey, you know, you decided it under 60B6, but it's silent as to 60B1. Did you do anything to try to get a decision on the 60B1?
I did not. So the other part of this, as the court's aware, is whether the decision falls outside the range of reasonable alternatives. In this case, what you have is a case hasn't even gotten past the pleading stage, based on the litigation that GENZYME has chosen, the litigation path that GENZYME has chosen to follow, which is their right, which is filing a motion to dismiss. This case has wound its way through the appellate court. It ends up in the SJC. The SJC issues the decision, and they dismiss the case. Well, a reasonable alternative to the judge's decision, rather than simply dismissing Mrs. Dunn's lawsuit, would be to allow Mrs. Dunn to file a second amended complaint to assert the facts that the SJC indicated were necessary to assert these parallel state law claims. And again, it's stated in my brief, but this whole issue with regards to how do you properly plead a parallel state law claim under the MDA that isn't preempted by federal law. That was a novel issue before the SJC. And so I recognize
standard pleading is not a novel issue. Iannacino has been around for a number of years, and you were aware of it going in. I mean, you had ample opportunity at any point before the SJC's decision to file a motion to amend.
I recognize that, Your Honor. If that was an error on my part, I will certainly own that error. But that's certainly not Mrs. Dunn's error. And I think
what did Dunn to tell you about what needed to be in your complaint that wasn't in your complaint?
When you say Dunn to, Your Honor, are you referring to the SJC?
The SJC decision, yes.
Okay, so the SJC was saying you have to provide some additional facts that draws a causal connection between the injury and the product. And
isn't that tort 101 though?
Well,
or negligence? I mean, that's not a new and novel legal construct.
No, it's not, Your Honor. But I personally thought that there were sufficient facts in the complaint that would meet the Iannacino standard, and the SJC took a different path on that. And I understand their position. They cited to the Bosch case that's referred to in the papers here as identifying the necessary facts that should be pled in order to assert this very, very narrow exception that would allow an injured party to bring claims against the manufacturer of a class 3 medical device. So you have a very narrow path there. I thought that I met it. Admittedly, I was wrong. Mrs. Dunn was not wrong. This was an error, I guess, by counsel, who was me, in doing that. And Mrs. Dunn shouldn't be precluded from asserting her claims, particularly when this case hasn't even really gotten off the ground with regards to pursuing the merits of her causes of action. So, you've read the papers. Obviously, you guys are very familiar with the standard of review. You're also obviously very familiar with the facts of this case, and I appreciate that. So if there's any questions that I can answer for you, I'm happy to do so with the limited time I have.
I don't see any, counsel. We certainly take all of your arguments that are contained in your brief. And you're welcome to use the additional time. If not, that's fine too. It's up to you.
Thank you very much. I will yield to my sister counsel.
Thank you, Attorney Dunn. Attorney Foote.
Good morning, Your Honors, and may it please the court. Catherine Foote on behalf of the appellee GENZYME Corporation. Your Honors, we believe that the Superior Court judge's decision should be upheld for 3 reasons. But before I address those reasons, I would just like to address a few points raised by the appellant. Our position on the SJC's decision is that, at oral argument, the appellant here requested that the SJC either allow her to uphold the denial of the motion to dismiss or allow her to amend the complaint to conform with whatever decision that the court issued. In deciding this case, and you can see that from the rescript, the court ordered the case dismissed and overturned the initial denial of the motion to dismiss. So it's our position.
Do you agree that it's without prejudice? Because if it was with prejudice, our case law says it needs to say that.
Yes, Your Honor, we agree that it was without prejudice. However, in reviewing the court's decision and reviewing the motion papers provided by Rule 60B, the Superior Court judge declined to reopen the case, and we don't believe that that decision was a abuse of discretion here.
So there was no open complaint when Mr. Dunn filed his motion for leave to file an amended complaint. So then, as I understand his argument, he was forced to file something in the nature of 60B. 60B1 was not addressed by the judge. So at a minimum, why shouldn't we remand it to address that claim?
Well, Your Honor, the motion papers extensively discussed Rule 60B. And it's not an abuse of discretion for the judge not to specifically in writing address those arguments in her decision. We believe that it's reasonable to presume that the court viewed all of the motion papers in totality and issued her decision, regardless of not explicitly stating that a portion of the basis of her decision was on 60B1. And if you look at the abuse of discretion standard here, and there isn't a clear error of judgment in weighing the factors. The factors are incredibly fact specific for each case. This case has an unusual procedural posture in that it went all the way up to the SJC and the Superior Court's original decision was overturned. But if you look at the totality of this case and the history of it, starting all the way back in June of 2018, when the initial complaint was filed, the DUNN had ample opportunity, both in response to the 93A letter that was sent to the court to GENZYME in response to the initial in filing the amended complaint, to bulk up the allegations there. Rule 15 of the Rules of Civil Procedure, in fact, provided DUNN the opportunity to amend the complaint as of right up to and until the court issued its motion to dismiss decision, which was almost an entire year after the original amended complaint was filed. And if you look to the SJC's decision on what the court is referring to as DUNN 2, the instruction as to what could have been included but was not included is not presented as a invitation to file a second amended complaint to address those missing facts. In fact, in the SJC's oral argument, quite a bit of factual information from outside the record was addressed and considered by the SJC, including much of which is currently in the second amended complaint. And that information didn't sway the court, and they still dismissed this case. And I think, looking at the SJC's decision, while the conclusion is a bit unusual and may appear to be missing certain instruction. If you look to a case in which the SJC actually did create a new pleading standard, the Yanakino case, the court both made it clear that they were introducing a new pleading standard and addressed that new pleading standard and defined it, but also provided the party explicitly in the decision the opportunity to file a second amended complaint and remanded the case in order to do that in line with the new pleading standard. In our reading of the SJC's decision, they did not do that despite counsel's request for that opportunity. Here
the trial court judge's decision dismissing it after the SJC case is essentially a clerk's notice. There's no memorandum of decision in order that I saw printed by the judge. Is that correct?
Yes, that's correct. There's the rescript opinion from the docket on February 4th.
And is it implicit that the judge dealt with 60B1 in that decision?
In the judge's decision on April 22nd, we believe it's implicit in that decision on the docket because this was an issue that was briefed and before the court, and we presume that the judge considered all of the arguments before her.
So whether there was an excusable neglect or inadvertence or surprise, any of those issues you feel is, even though not specifically those words used, that it's implicit in that decision?
We do, and we believe that the decision was correct because we believe that there was no excusable neglect here. All of the information now contained in the proposed second amended complaint is information that was known or entirely knowable to Ms. Dunn at the time of filing her original complaint. And we believe that it was a strategic decision not to include that information. And the Rule 60B standard and the case law regarding Rule 60B says that when there's a strategic decision that doesn't work out, that does not fall within the bounds of a Rule 60B extraordinary relief.
But
Oh, sorry. Go ahead.
Oh, go ahead, Rachel.
No, you're still going. I'll tag you.
Even though the SJC found that there was no pleading, a new pleading standard, they did not establish a new pleading standard. I mean, isn't this harsh in light of the process, the path this took along the pleading stage, not to allow them an opportunity to amend after the SJC decision in light of all of it was all about the pleadings all along, and now to say, well, you were wrong, so you're out, period. I mean, doesn't that seem overly harsh, and does harshness even play into a 60B decision?
While we appreciate that it could appear as harsh, there was a long history in this case of GENZYME taking a position that the complaint was wanting and missing a good deal of necessary information. And that was made clear to the plaintiff multiple times in writing, both through the response to the 93A letter and in the motion to dismiss. And those provided the plaintiff numerous opportunities, whether she agreed or not, to provide additional information in the complaint to address those concerns and prevent this from happening. And Rule 60B ultimately is supposed to have an extremely meager scope. And if we look at cases where it's dismissed at the motion to dismiss, this is something that frequently happens. Rule 12b6 motions are often the response to a complaint in civil cases. And simply because the case is dismissed doesn't mean that you're entitled to a Rule 60B motion. If that were the standard, then Rule 60B wouldn't serve its purpose.
Why do you think you're entitled to fees?
Well, Your Honor, in looking at the case law regarding attorney's fees, We were able to see that there were cases like this one in which the parties were routinely told that they had made the same argument in numerous instances, and it was unsuccessful each time. And in continuing to pursue those same unsuccessful arguments, it was costly for the party that had to continue to respond to those.
But I mean, it was a novel issue of law before the SJC, and there was certainly some question as to what a plaintiff in Mrs. Dunn's position was to do as a result of the rescript. I guess I'm having a hard time seeing that it's frivolous.
Well, Your Honor, while we think that it was a novel issue before the SJC, whether an elevated pleading standard or a heightened pleading standard was required in this case, at base, all plaintiffs must meet the standard outlined in Yanakino. And here, the plaintiff did not in the eyes of the SJC. And so, ultimately the decision was, while they viewed the novel issue, they addressed it at the same level as any other civil complaint.
Understood.
If Your Honors have no further questions, we respectfully request that the decision of the Superior Court be upheld, and we rest on our briefs.
Let me just make sure my colleagues are all set. Great, we will take the matter under advisement. Counsel, thank you both. Those were very helpful arguments and very helpful briefs. And this will conclude this morning's hearing.